Hi, welcome to the Labor Guilders Conversation Corner. This is content just for you as our way of being appreciative to your financial support of the Labor Guild. My name is Lisa Field. I'm president of the Labor Guild, and I'm joined tonight by Paul Kelly, who is a union attorney, one of the best here in Massachusetts. Paul, he's received the Cushing-Gavin Award and many other awards. And we're here to talk about the Glacier versus the Teamsters Supreme Court case. So welcome, Paul.
Thanks, Lisa. Nice to be here. And we get to talk about a Supreme Court case that was decided earlier this year involving a concrete company and a Teamsters local that represented the drivers. And the case began when the workers went on strike, and some of the workers after the strike were disciplined, and the reason they were disciplined was because they had mixers, concrete mixers, and they had been dispatched to deliver the concrete to customers of the company. And when the union said we're on strike, they drove the trucks back to the yard where the trucks were housed, and kept the drums rotating. But there was a danger to the product that it would go bad if it didn't get used, and there was a danger also to the drum. If the concrete hardens in the drum, then the drum is lost. Anyway, the union, after the strike was over, filed charges at the NLRB against the company because it disciplined the workers. The company responded by filing a lawsuit in state court in Washington. And the company alleged various counts in its complaint that the union had trespassed on its property, that they had tortiously interfered with contract, they had converted the product to their own use, and so forth. The union responded with a defense that has been common for the last 70 years or so. And that is that the state court case was preempted by federal law. In other words, federal law governs and state law does not. The state court judge agreed and dismissed the suit, and I believe the Washington Supreme Court agreed as well. So what we have is a complaint, simply a complaint. That we caused damage, we being the workers, caused damage to the ready mix company because they lost some concrete that didn't get delivered. And eventually the case gets to the Supreme Court. And the Supreme Court writes really four separate opinions. There's a majority opinion that was written by Justice Barrett and joined by Justice Roberts, Justice Sotomayor, Justice Kagan, and Justice Kavanaugh. And they reversed the decision of the Washington Supreme Court and the Washington trial court, and said that the matter was not preempted. Justice Thomas and Justice Alito wrote separate concurrences, and Justice Gorsuch joined in each of those, and they concurred that the decision, the judgment of the state court, should be reversed. And Justice Ketanji Brown Jackson filed the lone dissent in the case. So we're going to take a look at the opinions and what the court said about the facts in this case. The majority opinion starts by noting that the National Labor Relations Act gives workers a federally protected right both to join a union and to strike. And it also created the NLRB, an administrative agency that was designed to prevent unfair labor practices. It's a federal law, and it preempts state laws. So if a state law made it illegal for a private worker who was otherwise covered by the NLRA to strike, that law would be preempted because federal law gives them the right to strike. And the preemption law comes down to us from a 1959 case called San Diego Building Trades versus Garmin. And that case established a fairly broad standard of preemption. And by preemption, again, we mean when state law is not allowed to act. It is preempted by federal law. So Garmin involved the San Diego Building Trades, and they picketed back in the early 50s. They picketed a lumber company. Garmin was the lumber company. They were trying to organize the lumber company's workers, and the picketing was designed to force the company to recognize the trades as the representative of their workers. Curiously, what happened here was in Garmin, the union filed a petition with the NLRB. Often that's what you do in order to get an election and get certified as a bargaining agent. But the NLRB in that case declined to exercise jurisdiction over the case because apparently the monetary jurisdictional standard, there are monetary standards that the NLRB applies to decide whether you're covered by the law or you're not. And apparently back then they declined to exercise jurisdiction. So Garmin seized on the NLRB's declination and went to state court and asked for an injunction against the picketing and also damages. And the California courts then enjoined the picketing because they said the NLRB has declined jurisdiction, therefore state courts must have jurisdiction. And also because according to the California courts, the picketing violated one of the unfair labor practice provisions of the NLRA. And then the court also awarded the company $1,000 in damages. So that was the posture of the case when it went to the Supreme Court in 1956. It went up twice, as Glacier Northwest may well do. We'll have to wait and see. But the court held in the first Garmin case that the NLRB's refusal to exercise jurisdiction doesn't give the state courts the power to enjoin what is otherwise peaceful picketing. And it's important, I think, to understand when a court issues an injunction, it is what lawyers refer to as equitable relief. An injunction tells you to do something you don't want to do or not to do something that you want to do, and that is historically a form of equity. Legal relief is typically damages. And in the Garmin case, not only did the court enjoin the picketing, but it also awarded the company $1,000 in damages. So what happened, which is really a prelude to what happened in Glacier, is that the court sent the legal relief back to the state court after it decided that the state court shouldn't have enjoined the picketing. So anyway, it goes back to the $1,000 case, goes back to the Supreme Court of California, and the court affirmed it. And then it heads back to the Supreme Court of the United States because the building trades appealed that they should never have been liable for the $1,000 judgment. This time around, and it's significant for me because I spent a little time researching the history of labor law, but the justice who wrote the opinion in 1959 was Felix Frankfurter. He had as a law professor, he had championed the Norris-LaGuardia Act, which back before the NLRA was passed in 1932, the Norris-LaGuardia Act said state courts and federal courts were ousted of jurisdiction to issue injunctions in labor disputes, because that's how labor disputes were regulated before the NLRA. each state or each federal court would issue an injunction and tell the picketers to stop picketing. Anyway, Frankfurter wrote the opinion in Garmin and established what we now know as Garmin preemption. Federal law makes conduct unlawful and also protects conduct. So Section 7 gives workers the right to strike, the right to join unions, and it protects peaceful picketing. And in some cases, the federal law wants the parties to be free to use economic force to settle their disputes. That's what a strike is. And so Frankfurter said Congress has entrusted the administration of labor policy for the nation to a centralized administrative agency. And the primary jurisdiction of the NLRB requires that conduct which is arguably protected by Section 7, that's Section 7 rights of workers, or arguably prohibited by Section 8, which are unfair labor practices that could be committed by either unions or employers, that in those situations, both the state and federal courts have to defer to the primary jurisdiction of the board. And so the reason the Garmin standard is broad is that the standard is arguably protected or arguably prohibited. Generally, as Justice Thomas in the Glacier case will show us, generally you have to have an actual conflict between state and federal law, but not so here. And it is a fairly pro-labor standard because most state court actions in connection with a labor dispute have been preempted, historically have been preempted under the Garmin standard. So let's go back to Glacier. This is the majority opinion, and the Glacier majority tips their hat to Garmin. But they also parsed it a little bit. And they point out that the party asserting preemption must show that their interpretation of the NLRA is not contrary to the plain language of the Act or has not been authoritatively rejected by the board. And they say that the union needs to both advance an acceptable interpretation of the NLRA, but also put forth enough evidence to enable a court to find that the NLRA arguably protects the conduct in question. So the conduct in question here was driving your trucks full of concrete back to the plant and letting the employer worry about what happens to the concrete inside of them rather than taking care of it yourself. And so the court says, well, the union never did that here. The union never put forth evidence to enable a court to find that the NLRA arguably protects the driver's conduct. And therefore, they rejected the union's preemption claim because the union had not borne the burden of proving that it had the right to abandon the trucks. So the question here is, what did the workers do, and why did the court go beyond that? Having said that the union didn't bear its burden of proof, they could send it back to the state court, but the court went beyond that, and this is something that Justice Jackson takes issue with. The court says that there is board law that requires employees to take reasonable precautions to protect the employer property from foreseeable imminent danger as a result of a cessation of work. It's a burden on the workers to not go out of their way to put the employer's property in harm's way. And a majority of the court here said that on the bare complaint that was before the court, that there was enough evidence to support the proposition that the employees failed in that burden. The union pointed to cases involving perishable goods, milk cases and cheese cases and poultry cases, but court distinguished between foreseeable risk and imminent harm. Now, this is the kind of, this is an aside, this is not the court speaking, this is Kelly speaking. But there's the kind of line drawing that is required to distinguish between foreseeable risk and imminent harm is something that the NLRB does every day. And it is one of the reasons why the NLRB has primary jurisdiction. But the bottom line for the majority was because the union took affirmative steps to endanger Glacier's property rather than reasonable precautions to mitigate the risk, the NLRA does not arguably protect the conduct. It's not arguably protected, and therefore the judgment of the state court, which relied completely on Garmin's arguably protected prong, was reversed. Now, Justice Thomas wrote a concurrence, but it is clear where he was coming from. Justice Thomas says, "I write separately to emphasize the oddity of Garmin's broad preemption regime." He would say, even though precedent is otherwise, he would say that only where state law and federal law are in logical contradiction should state law be preempted. So he took aim, Justice Thomas, and he was joined by Justice Gorsuch. They both said that this Garmin preemption is too broad. Justice Alito took a different tact. He said that workers don't have the right to destroy an employer's property as part of their right to strike. He cites cases that says that. He completely ignores the nuance of what's a perishable product and whether the drivers did anything illegal when they returned the product to the plant and turned them over to the company. And he states he held or stated, Alito did, that long ago the court had decided that this type of conduct was not protected. So you've got the five justices who were in the majority, and you have Alito, Thomas, and Gorsuch who concurred, all holding in one way or another that preemption was improper in this case. Now, Justice Jackson dissented. She's the only one that would have upheld the state court. And she takes notice of the charges that were filed against the company by the union. And what happened in this case is that it moved fairly quickly because the complaint was filed in state court. The state court judge threw it out because it was preempted, and the Washington state court affirmed that. While that was going on, the board was investigating these charges that some of the drivers were disciplined for, returning to the what happened on the day of the strike was that the union told the workers to return the trucks to the yard, and the employer told the workers to continue delivering the concrete to the customers. The workers returned the concrete to the yard, and the company disciplined them for being insubordinate. The union filed a charge against the company that the company was interfering with Section 7 rights. The company then sued the union because it had put the trucks in danger, and it had wasted all the concrete that was in the drums. And the union amended its complaint to include that. So while the case is winding its way up to the Supreme Court, the board is now investigating it. And eventually the board issues a complaint and says, we agree with the union, or at least the regional director agrees with the union that the discipline of the workers and the filing of the lawsuit violated the statute. So she reviews the history of the National Labor Relations Act and deferral as the majority did. And she says that what a court should do in this situation where the board is investigating a charge and eventually will determine whether the conduct is actually protected or actually prohibited, that the state court should pause and wait for that determination to be made. And she notes that the majority remanded the case to Washington to consider the impact of the board complaint. But she also says the majority shouldn't have it both ways. On the one hand, they send the question back for the impact of the board complaint on the state proceedings. But on the other hand, the majority just went ahead and decided the merits of the matter without deciding, without letting the board make the decision. She said something which I thought was noteworthy because I've felt this way before myself. She said, "Workers are not indentured servants, bound to continue laboring until any planned work stoppage would be as painless as possible for their master. They are employees whose collective and peaceful decision to withhold their labor is protected by the NLRA, even if economic injury results." So that's the summary of Glacier. It appears that that 8 out of the 9 justices would agree that on the face of the complaint, the case should not have been preempted. They should have let it go forward. And I assume they would agree. There's an odd thing happened in this case, that the impact of the board charges are critical in cases like this, and yet they were ignored. And I guess everybody agreed, or at least the NLRB agreed, that the complaint should not be taken into consideration, and the majority didn't. They didn't consider it. Justice Jackson, she did consider it, and she thought it was dispositive, as a matter of fact. But remember, the case has not yet been tried. All we had was a complaint. It'll probably be tried at the board, and unless it settles, we'll have to see later on what happens. But it is clear that the court is taking a swing at broad Garmin preemption.
So kind of a couple of basic questions. So kind of bottom line, what's the implication here and now for unions, I guess? Unions, if they're planning on going on strike, what would be the bottom line right here and right now? If my union was deciding to go on strike, is there something about this court case that we should pay attention to?
Well, the advice for unions is, if you have an opportunity to file a charge at the board because the employer is infringing on the Section 7 rights of the workers, you should do that. You should do that. That puts in place the federal-state dichotomy right there. If you don't do that, then it appears as though federal law does not offer any protection for you. And in order to establish federal preemption, we want to have an authoritative ruling from the board. So if there's a reason to file a charge, you should go ahead and do it.
And you were talking about that the Garmin case had gone twice to the Supreme Court, and that there's a possibility that this one might too. Is it because that stuff got remanded? I'm trying to understand that piece of the process.
Well, it got remanded. It got remanded to the state court. And I think in defense of the majority, okay, one of the things that happened here is that the board complaint came out before the case got to the Supreme Court, but after the state courts had already decided it. And typically, a court like the Supreme Court doesn't want to do anything but review what happened below. So if there's a new fact that shows up, they want the state court to figure it out and do what they want to do with it, and make a decision based on that. And if there's a way of defending the majority decision, it is that it was only a motion to dismiss, and you should leave it. Now, Justice Thomas, I think he writes a footnote and says he would like to have the case come back, because if the state court find it to be preempted, he'd like to take another swing at Garmin and maybe, it sounds like, maybe overrule it. So he says something about, let's give it a quick return trip.
Now, were you surprised about how it kind of went down, that there was only one actual dissenting vote here, and then the rest of them all kind of went? Were you surprised?
Well, yeah. I was a little surprised. And I would have preferred that they just send it back and let the state court take evidence. It's a little unfair, in my view, that you take a case on a motion to dismiss. There's been no hearing, there's been no evidence, there's been no nothing, and then you tell the union that hey, you didn't provide enough evidence to convince us or convince the state court that your conduct was protected. That's essentially what they did, and I think they could have decided the case that there wasn't enough for preemption at that point, without deciding authoritatively, which is what they did. And this is what Justice Jackson challenges them on. She says, well, if it's broad enough that it may not be preempted, let it go. Let the state courts do it. You don't have to weigh into it yourself and figure out what's imminent harm and what isn't. Those are the kinds of decision the board is made for. So it wasn't the best. It wasn't the best case in the world, and I don't think it was the best outcome either, because it suggests the lesson we're going to get out of this case is that I was telling you earlier, the ship in the middle of the Atlantic when the strike happened, and they had to get the ship safely into Liverpool and tie it up and then go on strike, even though the strike had happened days before. So. But this is sort of a warning. Watch out, you unions. If your employers suffer economic harm as a result of your strike, we may not be helping you. And at least historically, the law has protected unions from that sort of state court mischief.
Now, are there other cases we should be watching too? That sometimes there are other cases in the pipeline that have been flagged that we should watch for too, as well.
I don't know if there's any like this one coming up. It's been a while since we've had a Garmin preemption case, but I wouldn't be surprised if this, unless it gets settled. Now, sometimes, as we know, these cases are sort of more expensive than they're worth, and this could easily be settled, but sometimes powerful interests have reasons to go forward, so it could show up again.
So, but if it gets settled, but still their decision. I guess just want to understand the process. So if the company, if it gets settled along the way, there's precedence now with the Supreme Court ruling, though.
There's a Supreme Court precedent saying that if you place your company's product in, in the risk of imminent harm, you're going to be liable. That's really what it says, or you could be liable under state court, which is why if you get caught in that position as a labor organization, you're going to want to make sure that your conduct is peaceful, because peaceful picketing, peaceful striking is protected, and any challenge to your method of picketing or striking is the subject of a charge to the board.
Interesting. So Andrew, do we have any questions in the chat? We asked people to put questions in the chat. Nope, nothing yet for questions. You put it in our chat. Interesting. Any other impact do you think that comes out of this one court case?
I think the good news is that it could have been worse. It was sort of teed up to be a case that would overturn Garmin, and it didn't quite get there. And perhaps we should be thankful that the majority found a way to save that from happening, because there's likely to be at least 4 votes to reverse Garmin, at least 3, I guess. But
interesting. Always shocking, right? When a case comes down, was it truly unexpected? That's what it seems like. That it was like, wait a minute, what?
No, it was expected to be bad. I think it didn't turn out as bad as it could have been, and there were people out there encouraging the Teamsters to settle it. So it didn't show up as a bad precedent. But
got it. Interesting. Interesting. Wow. Interesting.
Well, it is. To me, what's interesting is the sort of historical context here, because labor organizations were regulated by, state court judges for the first 45 or 50 years from the Industrial Revolution, and the picketing was enjoined, and there was nothing you could do about it, because it was a conspiracy. It's a conspiracy and restraint of trade is what they used to say, and so we're going to enjoin you. Justice Holmes dissented in a case in Massachusetts back in the 1890s, and he said something which I have taken to heart. One of the eternal conflicts out of which life is made is that between the effort of every man to get the most he can for his services, and that of society disguised under the name of capital to get his services for the least possible return.
Wow.
Combination on one side is patent and powerful. Combination on the other side is necessary and desirable counterpart if the battle is to be carried on in a fair and equal manner. But that's what was going on. That was a case, and he dissented in that case in Massachusetts. This was 2 guys picketing in front of a shop, and the Supreme Court of Massachusetts enjoined the picketing, and he dissented from that. But that gives you an idea of the history, and that's why the Norris LaGuardia Act, which was 1932, and actually Frankfurter was a law professor. I think he was a Harvard law professor, and he wrote the book called the Labor Injunction, and he was one of the authors of the Norris LaGuardia Act. But that took the injunction out of play. Although curiously, in the National Labor Relations Act, Congress gave the board the right to go get an injunction if they think the circumstances warrant it. So anyway.
Very interesting.
It's interesting. It's interesting. And so federal law was, back in the 50s, federal regulation over labor, and 59 is a big year, because this is when Landrum Griffin was passed, and unions were quite regulated. But there was no question back then that federal law was the governing law. But pendulum always moves the other way.
Always swings. Let's see if there's any questions. Any questions, Andrew? Still nothing. Still nothing. Well, thank you very much for this. It was very interesting to see the connotation, the context.
Well, I'm happy to be with you. I don't think I've done this before, so I'll go on the Guild website one of these days and see what the old guy looks like.
There you go. You did very well.
Good though, Lisa.
You did very well.
Thanks, Mary G.
Thank you very much. Thank you very much. This has just been very interesting. And to everyone, this is now recorded, so you can come back and check it out anytime. We're going to continue to do these type of programming for you. Again, this is to thank you and to show our appreciation for your financial support. So don't forget to keep checking here to see what else is going on, because we're trying to come up with some really interesting topics. And don't hesitate to drop us a line, either right here on Facebook or call the office to give us any great ideas. We always love your ideas. So thank you very much. And thanks again, Paul. We really appreciate it.
Thanks for doing it, Lisa.
Thanks.
See you soon.
Take care. See you soon.